Hello and welcome to our Procurement Act Insights podcast series. The Procurement Act 2023 marks a significant shift in public procurement in the UK, introducing new procedures, obligations and opportunities for local government. Whether you're working in procurement, part of the legal team or commissioning, it's essential to understand what these new changes mean in practice. To support you through this transition, Sharp Pritchard procurement specialists have created a series of short sessions designed specifically for local government to help you understand and apply the new procurement rules. Each session has a voiceover from our procurement experts with easy-to-follow slides, is relatively short, 30 to 40 minutes, and can be accessed on demand and returned to at any time, so perfect for busy teams. After a long and winding road since Brexit, the new procurement reforms finally went live on 24th of February 2025. The material in this presentation is based on the Procurement Act 2023 and the Procurement Regulations 2024 and related material valid at September 2025. We've tailored the content of each episode to focus on key PCR 2015 related changes relevant to local government, but do be aware that there are some differences between local government and central government procurements, and also for the defence sector, and for utilities, private utilities, and for utilities contracts. We hope you enjoy our insights. In this first episode of the series, I'll be giving you an introduction to the procurement reforms. I will also give you an overview of what has changed and talk to you about the application of the rules, the new objectives, and the new overarching duties under the Act. I'll be covering an introduction and some context, what's changed, what's a covered procurement, who are contracting authorities under the new rules, public contracts and exemptions, overarching objectives and duties, and then finally I'll give you a guide to some further reading material. So what happened on 24th of February 2025? The first major change is that the old regime, as I've set out on the left-hand part of the slide here, so PCR 2015 and the other regulations that derived from European law, have been revoked and replaced by the new regime, which is the Procurement Act 2023 and the accompanying regulations, Procurement Regulations 2024. And what are the new procurement rules? So procurements commencing on or after 24th of February 2025 must comply with the new regime. So as we saw on the earlier slide, that means the Procurement Act 2023, which sets out the primary obligations in relation to procurements, and you can see the link there. And the Procurement Regulations 2024, and these set out detailed requirements. So, for example, the Act provides an obligation to publish a notice, but the Procurement Regulations 2024 set out what that notice needs to contain. So you need to review the two together. But don't throw away your copy of PCR 2015 just yet. Procurements commenced before 24th of February 25, so the go-live date for the new Act, or contracts or frameworks awarded under the old regime will continue to be subject to the old regime. And that's by virtue of these commencement number 3 regulations and the transition and saving arrangements set out in that regulations that we set out on the slide there. And what that means for you in practice is that if you've commenced a procurement under the PCR 2015, but you haven't yet awarded it, you can continue to procure your contract or framework using PCR 2015 until you've awarded. And in fact, the management arrangements that are set out in the Act won't apply to that contract because you've procured it under the 2015 regulations. The other thing to bear in mind is if you've got a contract that you've awarded under PCR 2015 and you want to modify that contract in the future, the modification provisions in Regulation 72 of the PCR 2015 will continue to apply to you rather than the new modification regime set out in the new Act. So for a time, we're going to have parallel processes and regimes, and you just need to be mindful of when you're looking at advising on a contract or a procurement, which regime you're in. So Procurement Act 2025 guidance documents. The other thing that's relevant to the new regime, as well as the Act itself and the Procurement Regulations 2024, is a set of guidance documents that have been published by Cabinet Office, and you can find those at the link on the slide here. This is a set of guidance published by Cabinet Office, which is intended to provide technical guidance and help with interpretation and understanding of the new regime. But be aware that this is not statutory guidance and it doesn't have legal status. So although it's important and the guidance is very helpful in understanding the intention and how you might interpret provisions in the Act, it doesn't have the status of statutory guidance. And it's interesting because there are some instances where the guidance doesn't seem to completely align with the plain words used in the PA23. So, for example, the PA23 guidance states in some places that there is no intention to change the existing law despite different wording used in PA23 compared to PCR 2015. And there's been a lot of commentary on this and what that difference means. But note that if there is a challenge, a court would interpret PA23 based on what the words used actually mean rather than what the guidance says they mean. PA23 context, what are the policy aims? So the previous Conservative government's stated aims for the reforms were, as I've set out on the slide here, and these are interesting to review now because partly the reforms can be seen in the light of the position we had post-Brexit and also what was happening politically at the time the bill was passing through Parliament. And we had at that point lots of scrutiny about COVID buying decisions and challenges by Good Law Project, for example, which had created a lot of emphasis on the negative aspect of procurement. So the stated reasons for the reform were to create something that was simpler and more flexible, i.e. in comparison to the old European regime, to open up procurement to a wider set of businesses, including SMEs and social enterprises, and also to embed transparency and allow for scrutiny of spending of taxpayers' money. And the current Labour government has stated its vision for the reforms in a series of mission statements and priorities that are now set out in one place in the new National Procurement Policy Statement. And I'll say more on that later. So what's different? I've set that out on the slide here, and I'll run through the key differences. First of all, new procurement objectives replace the old procurement principles. I'll come on to that in a moment. New procurement language throughout. New notice requirements. There's a new digital platform, which includes new supplier registration system. And this is an upgrade of the old FTS system. And the idea there is that all procurement information can be in one place and better information can be available for monitoring the output of procurements. There are new procurement routes and routes to market. There are new rules on conditions of participation that replace the old PCR rules on selection criteria. There are new rules on exclusion of suppliers. And there's a new central debarment list for excluded suppliers. There's also a new requirement to prepare a conflicts assessment and enhanced conflicts obligations, new express rules about refinement of award criteria, and new express rules allowing modification of a procurement. So new rules replacing those that are currently in PCR Regulation 72. And there's a new procurement oversight unit in the form of Procurement Review Unit, or PRU. There are new contract management requirements post-award, which I'll come on to talk about in a moment. And finally, there are new requirements to set and publish KPIs for contracts over 5 million. On the right-hand side of the slide, I set out some examples of this change in language that I've mentioned. So the first big change is that the old contract notice that we know and love under PCR is now called tender notice in the PA23. Selection criteria become conditions of participation. No more evaluation references. References are now to assessment. Most economically advantageous tender becomes MAT, the most advantageous tender. No more standstill letters. These become assessment summaries under the Act. And contract award notices are now called contract details notice. And that last one is a bit confusing because the Act does contain a contract award notice, but that's now a notice that you publish before you enter into the contract. And the notice under the Act that you publish after you've entered into the contract, i.e. our current PCR contract award notice, is now called contract details notice. And what's similar or unchanged? I mean, you will see as you get more familiar with the Act that actually a lot is pretty much the same as you were used to using under PCR. So, for example, the types of contracting authorities and utilities are covered are broadly the same. Types of contracts covered are broadly the same. The financial thresholds that you're used to applying are broadly the same, and they will continue to update every 2 years. The list of exempt contracts is broadly the same, and the minimum time limits to run a procurement process are also largely unchanged. As I said on the earlier slide, the approach to evaluation, or now assessment, is called most advantageous tender rather than most economically advantageous tender, but we think that's more a change of form over substance, and that actually is emphasised in the guidance, that the loss of the economic doesn't mean that price is no longer important or value is no longer important, but the change in terminology is a change in emphasis to encourage authorities to look at value, social value, for example, wider than just the economics, the pure price. The requirement to debrief at award stage and to allow a standstill period before entry into the contract remains, although there's some slight differences in language and terminology. The rules about challenge rather, and the routes to challenge and remedies essentially stays the same, although again, we'll cover in another episode some slight differences in language. Duty to keep records in Section 98 of the Act is essentially the same duty as we currently have under PCR 2015, although there is some slightly different wording and some augmented provisions. And the safe harbours that we're used to operating within under Section 72 of the PCR to modify contracts post-award remain, although there are some changes from the old 72 rules and some new safe harbours. So I'm now going to look at the general application under the Act so you can understand how the Act is applied. So first of all, what procurement contracts are covered? PA23 distinguishes between a procurement and a covered procurement, and the purpose of this distinction is to make clear that the full provisions of PA23 only relate to covered procurements. However, note that PA23 also applies some separate and limited provisions to procurements in a wider sense. So, for example, there are particular requirements that apply for certain below-threshold procurements. The non-discrimination obligations with respect to treaty state suppliers apply to below-threshold and exempt procurements, and authorities have a duty to have regard to the National Procurement Policy Statement, that I'll come on to explain in a moment, even if you're just talking about a procurement rather than a covered procurement. And note that there are also some difference for what are now known as special regime contracts, and those are concession contracts, light touch contracts, defence and security, and utilities contracts. So looking more detail at procurement and covered procurement. So looking at more detail about what we mean by procurement and covered procurement. PA23 Section 1 defines what we mean by procurement and covered procurement as set out on the slide here. And I've highlighted the wording management of a contract and management of a public contract because this is the real distinction in PA23 compared to what you currently have in PCR 2015. So a procurement means the award, entry into and management of a contract, and a covered procurement means the award, entry into and management of a public contract. And the distinction here between what you're used to operating under in PCR is that the definitions make clear that the Act applies to the whole life cycle of a procurement, including post-award. And that, in theory, might mean a greater risk of challenge, because you have to be mindful not only of the Act's provisions and the objectives of the procurement while you're procuring your contract, but also while you're managing it. So who's a contracting authority under the Act? This is defined in section 2.1 of the Act, and which provides that a contracting authority means a public authority, or B, in the case of a utilities contract, a public authority, public undertaking, or public utility other than an excluded authority. And PA section 2.2 defines the public authority, public undertaking, and private utility by reference to the following tests. So we're looking at how an authority is funded, the extent to which an authority has oversight, whether or not the entity is operating on a commercial basis, and whether or not the entity is undertaking a utility activity. Now, for local authorities, the test is relatively clear, and you ought to be a public authority for most purposes under the Act, and therefore squarely a contracting authority. So not really a difference there from how we operate under the old regime, PCR 2015. And that's confirmed in the guidance about the contracting authority definition, where Cabinet officers confirmed that they didn't intend to make any difference to the scope of entities covered under the Procurement Act. So what is a public contract? So you'll remember that the public contract is what is covered in the definition of a covered procurement. So that's the procurement of a public contract. And a public contract is any contract for the supply for pecuniary interest of goods, services, or works to a contracting authority, or any framework or any concession contract. And the change here, the key change between PA23 and PCR 2015, is that we now have concession contracts included within the ambit of the Act, rather than as a separate regime, as we used to have under the old regime, where you had a separate set of regulations covering concession contracts. And you're a public contract, a contract, a framework, or a concession contract if you're over the estimated value and you're not an exempted contract. So I'm now going to come on to have a look at what we mean by the threshold amounts and what we mean by exempted contracts. So firstly, threshold amounts. You'll be used to seeing these. This is the same thresholds that are set out in the PPN, and a similar set of thresholds applicable to the different sorts of contracts that might be procured as you were used to operating under PCR 2015. Note that the threshold amounts are now inclusive of VAT, so you need to be aware of that when you're calculating your estimated value. And the key difference as well highlighted on the slide is that for sub-central government authorities, which include local government, the threshold for supply of goods or services is slightly higher there, 214,904, compared to the threshold that's applicable to central government authorities. But otherwise, the threshold amounts for concessions and works are the same. But note that there are some different thresholds for utility contracts, if that's relevant to you as an authority, light touch contracts, and below threshold contracts. And just as a word of caution, the drafting in PA23 Schedule 1 isn't very clear, but if you look at the PPN relating to thresholds, that will help you, and the guidance note will help you understand, but essentially they are as we've set out on the slide here. And then exempted contracts. So considering whether the contract you're wanting to procure is in fact exempted from the rules, you now look at PA23 Schedule 2. And Schedule 2 is separated into two parts, as we set out on the slide here. Part 1 covers counterparty exempted contracts, and those are essentially the rules that you're used to managing in PCR 2015 Regulation 12, and they're broadly equivalent to those old provisions. So you have vertical arrangements and horizontal arrangements, so contracts between cooperating authorities. So those are set out in Part 1. pretty much in the same terms as you're used to seeing in PCR. And then part 2 of Schedule 2 is what's called subject matter exempted contracts. And again, those are broadly equivalent to the old provisions that were set out in PCR 2015 Regulation 10. So the type of contracts that are exempted from the rules are some kinds of legal services, employment contract, land agreements, financial services. So those kind of exemptions are those that you're used to operating within. And then just to note, the other exemptions, the PSR are subject to a different regime. And noted as well that I mentioned already, there's a set of special regime contracts now defined in the Act, utilities contracts, and contracts procured by private utilities in the defence sector that have slightly different rules and different exemptions. So do be aware of those if you're procuring any of those categories of contracts. So now I'm going to come on to look at some of the procurement objectives and the overarching duties under the new rules. So I'm now going to look at the new procurement objectives under PA23. These are set out in section 12, and I've summarised them on the right-hand side of the slide here. The old regime, PCR 2015, had a set of overarching procurement principles that we're all familiar with. They were set out in Regulation 18 of PCR, and they're set out on the left-hand side of the slide here. Equality, non-discrimination, transparency, and proportionality. And you'll be aware that those terms and those principles derived from European law. So post-Brexit and the implementation of the new procurement reforms saw a change of emphasis and a move away from these old European principles. So we now have these new procurement objectives. And the other thing that's slightly different is that the Regulation 18 is expressed as a mandatory requirement to comply with those principles. So an authority was under a duty to treat tenderers equally. And the procurement objectives in the Act are expressed slightly differently, as you'll see on the slide here. So a contracting authority must have regard to the importance of delivering value for money, maximising public benefit, sharing information, and acting and being seen to act with integrity. So some of those concepts we're familiar with, and their public law principles or their duties that a local authority is already subject to. The sharing information objective is equivalent to the transparency principle under PCR. And in subsection 2 here, an absolute duty this time, to treat suppliers the same unless a difference between the suppliers justifies different treatment. That's a slightly different formula, but it's essentially intended to mean the same as the old transparency duty. And then finally, we have the duty in section 4, subsection 4, in carrying out a covered procurement, a contracting authority must have regard to the fact that SMEs may face particular barriers to participation, and a duty to consider whether such barriers can be removed or reduced. So things to notice there is the first set of objectives are a must have regard to the importance of duty, whereas the duty to treat tenderers the same and a duty to consider the relevance of SMEs are a must. So just looking at that in a little bit more detail, what's happened to the non-discrimination principle? So you'll remember under PCR Regulation 18.1, there was an absolute duty for economic operators to be treated without discrimination. And that doesn't appear in section 12 that we just looked at, but it hasn't been lost altogether. It now appears in section 90 of the Act, where there's a duty on contracting authorities to not discriminate against treaty state suppliers. So it's in a slightly different place and form, but it hasn't disappeared altogether. It's in section 90. What's happened to the proportionality principle? So again, we're used to seeing that as one of the procurement principles in Regulation 18 of PCR, and you'll have noted that it didn't reappear in Section 12 as a general duty, but it hasn't been lost altogether. So there are various examples that I've set out on the slide here in the Act where there is reference to proportionate. And you'll see the examples there. So, for example, Section 23 of the Act requires that a contracting authority must ensure that the procedure is a proportionate means of awarding the contract, having regard to the nature, complexity, and cost of the contract. So, although proportionality is lost as a procurement objective, it does still appear in certain places in the Act. And what's happened to the transparency principle? Again, Regulation 18 of the PCR had that as one of the overarching principles of procurement. And transparency as a term doesn't appear in the Act. And you'll have seen that it didn't appear as a Section 12 covered procurement objective in quite the same form as it appears in PCR Regulation 18, but it is still there, and the guidance makes clear that transparency as a theme and as a principle is throughout the Act. And one of the things that I mentioned already is in Section 12, there is a duty for a contracting authority to have regard to the importance of sharing information. And other examples of transparency type principles in the Act are contained in the obligation to publish various notices throughout the procurement life cycle, a duty to keep conflict assessments and share information as required is set out in a number of places in the Act, as we've set out on the slide there. So just because it's not in Section 12 as a transparency duty, it's not lost and still a key theme for authorities to be aware of. So, National Procurement Policy Statement. I mentioned this before. This is one of the new provisions in the Act and a distinction between the Act and the old regime. The duties relating to the NPPS are set out in Section 13 of the Act. The NPPS is a statutory statement which allows the government to set and communicate wider objectives that it expects public procurement to contribute to. And Section 13(9) sets out the obligation for contracting authorities, and that's an obligation for authorities to have regard to the National Procurement Policy Statement. And there's been lots of talk in the media and in academic commentary on the Act or on LinkedIn that the National Procurement Policy Statement is an absolute duty and authorities have to comply with it. And that's not quite right. A contracting authority must have regard to the statement. And what is the statement? The current one, it was published on the 12th of February 25 by the Labour government, and it sets out key themes, which I've set out on the slide here. So driving economic growth and supporting SMEs, promoting social value, enhancing commercial and procurement delivery, and building skills and capability for procurement. So a duty as a contracting authority when you're designing a procurement and when you're running the procurement, and in fact, as you saw in the definition of covered procurement, when you're managing your contract, you must have regard to the National Procurement Policy Statement. And what is a duty to have regard to? Well, it's not an absolute duty, and that's important. So when you're looking at Section 12 objectives and you're looking at Section 13, duty to have regard to the NPPS, it's not an absolute duty. The duty is that the contracting authority takes into account those objectives and the duty to have regard to the NPPS. And if you depart from those duties, those principles, then you must have clear reasons for the departure. And those reasons, I would say, need to be documented in your procurement record. So when you're designing your procurement, it will be important in your procurement plan or whatever the authority's record is for getting a procurement approved before you launch, it will be important to record how you've had regard to the MPPS, so that you have that audit trail to show that you've had regard to it, and if you've departed from it for any reason, that you've articulated the reasons why you've departed from it. So finally, reading material relevant to this episode, I've set out on the slide here. Again, really important that you familiarise yourself with the Cabinet Officer's guidance for procurement. And I've set out on each slide the relevant parts of that guidance that are applicable to each of the slides. And then we've also included links there to the government commercial functions learning modules. Module 1 is relevant to this episode. And do also have a look at PPNs that have been published for Procurement Act 23. We have a new set of PPNs that are available at the link on the slide here. So we hope you enjoyed this episode of our practical insights into the Procurement Act. Please do listen to the rest of the series for more insights relevant to local government. If you want to discuss any issues raised in this episode, or if you need assistance with a procurement matter, please do get in touch. Thank you for listening.